Self-defense is a great defense in cases like assault or manslaughter or domestic assault or attempted murder. But a lot of people think, well, you can just say, well, I was defending myself, and that qualifies as self-defense if a jury believes you. That's not the case. If you're in trial in Minnesota, it's first the defendant's job or their lawyer's job to convince the judge that at trial, as the evidence comes out, there's enough facts there or enough of a dispute about the facts that you qualified to even have the self-defense jury instructions read to the jury before they deliberate. If a judge determines that you haven't at least met a burden of the initial elements, then you won't even get to have the jury read the self-defense instruction, and they don't get to deliberate about whether you were acting in self-defense or not. So it's first the defendant's job or your lawyer's job to qualify for self-defense. Once that's done, then the burden is on the state beyond a reasonable doubt to prove that you were not acting in self-defense. To be qualify for self-defense in Minnesota, you have to meet certain what are called elements or ingredients of self-defense. What's read to a jury if you qualify for the self-defense instruction is that you're not guilty of a crime if you used reasonable force against someone to resist or to aid in resisting an offense against somebody, whether that offense is against you or one of your friends or somebody you're with. If you're going to defend them and you believe that you or they were about to be hurt, it says that it's lawful for someone who's being assaulted and who has reasonable grounds to believe that bodily injury is about to be inflicted upon someone to defend from an attack. In doing that, you can use all force necessary that you reasonably believe to be necessary, and that would appear to a reasonable person to be reasonable in similar circumstances to prevent bodily injury that's about to happen. So in other words, not only do you, while you're in the moment, have to believe that your force is necessary to defend yourself, but a reasonable person, which a jury is always going to think that they're reasonable people, they also have to believe that if they were in your situation, that you reasonably had to defend yourself. You can use all force necessary as long as it's reasonable. You can't use excessive force. So the kind and degree of force that you can use lawfully in self-defense is limited by what a reasonable person would regard in the same situation to be reasonable and necessary. Any force that's beyond that is considered excessive and isn't allowed under the law. You also have the legal excuse of self-defense is only available if you're acting honestly and in good faith. This includes the duty to retreat or avoid the danger if reasonably possible, and those are important words. Prosecutors will often say or argue to a jury, well, you know, he or she could have ran away and then they wouldn't have had to defend themselves. Well, that's not always the case. Sometimes your friend is about to be hurt and you're not going to leave your friend hanging there high and dry. So that's one thing to look at. Another time, you can't get away either because you're in a closed space, because the person has grabbed you or otherwise confined you, or there are other factors that make it unavailable for you to retreat. So if reasonably possible is key words there. Finally, with respect to self-defense, you can't, if you're the initial aggressor in an incident or the initial assaulter, you then can't just use self-defense right after that. You have to first try to end the conflict before you can defend yourself. So here's how that works. Normally, if I'm not the aggressor, if somebody comes at me, I can defend myself if I think I'm going to be hurt, and I can use all reasonable force necessary to defend myself. However, if I'm the aggressor, so if I'm coming at you and I push you really hard, or I come up and I punch you, and then you come back at me and now I want to defend myself, I can't defend myself right off the bat and use the legal excuse of self-defense in court. What I've got to do if I want to say, hey, I was using self-defense in court, if I'm the initial aggressor, is after I use the initial aggression, before I can defend myself, I can't just stand my ground. I have to first decline to carry out an assault or have honestly tried to escape from it. And I have to clearly and fairly inform you of my desire for peace and abandonment. So again, if I come up to you and punch you out of nowhere, and then you come up to me and you're going to punch me, I can't then punch you again and say I was acting in self-defense. First I can punch you, and then before you punch me back, or even after you punch me back, before I can hit you again, I have to say, wait, I'm sorry, this got out of control. I don't want to fight. I'm trying to end this. And then and only then, if you continue to come at me and you're about to hit me, can I defend myself again. That's called self-defense, revival of aggressor's right to self-defense. So self-defense is a great defense in assault and those sorts of cases, but you have to qualify for it under the law, and a skilled criminal defense lawyer knows how to convince a judge under the facts or develop the facts enough so that you have the best shot of having the self-defense instruction read to the jury and then knowing what a prosecutor is going to argue against self-defense. At the end of the day, if you're acting in self-defense, it's something you should sincerely consider before agreeing to plead guilty to any sort or level of assault. If you have other questions, my name is Ryan Pacyga. You can find me at arrestedminnesota.com or at 612-339-5844. Good.